I appreciate you coming back today. Yesterday, we went through some really good foundational materials. We took a look at treaties from the international level and started talking about Indian treaties. Again, here's a list of the sessions that we have upcoming today: Indian treaties and history, and the impact really of history on Indian treaties. So we're going to have two parts again to our session today. We're going to break again about an hour into it just to let some of it settle in, and then we'll get to the real meaty stuff after the break. The first is just a little bit of a review, and then we're going to go into an overview of federal Indian law. So my disclaimer is that you cannot practice Indian law with my little quick overview today. I'm not going to go over a lot over jurisdiction, some really core things that you would need to really know Indian law. You can study Indian law for years and still be learning about it. So, but it's just to get us all at a baseline understanding of some basic concepts before we get into the history, because if you don't understand those basic concepts, the history is not as meaningful once we start discussing it. So part two, we're going to go through an overview of federal Indian policy, and this is what's going to take a lot of work for us to go through. We're going to go through some historical context. Now, there are other things that are going on in the world in the United States that I will only mention that may not end up on the screen, but you can only put so much of what's going on at any given time before it becomes overwhelming to you. So I've picked a few things. And then we'll talk at the end about the transition from treaties to statutes. And we talked a little bit about that yesterday, about how once treaties are ratified, their legal effect becomes equivalent to that of a federal statute here in the United States. See how much you learned yesterday? So let's get into a little bit of a review. Yesterday, we talked about a legal system. We're going to talk about the federal legal system today. I brought the slide back so that you could focus really on that second bullet point, that legal systems help and hinder interactions with other societies. That is really going to be the theme of today's presentation, of times that federal policy is supposed to help, and sometimes federal policy has been created specifically to hinder. And sometimes good intentions just end up with very negative repercussions. So again, a reminder that we will be talking about tribal sovereignty later in this presentation today, but a reminder that sovereignty is the inherent power. It's not granted by anyone to that sovereign authority. They have derived that organically, naturally. They have the authority to govern over their specific jurisdiction. And remember, when we talk about jurisdiction, it can be territorial, and it also can be over people. Now, when we get into legal jurisdictions, there are more types of jurisdictions, but for today's discussion, let's focus right now on these types as they relate to the general concept of sovereignty. So I want to remind us some of the things that we went over yesterday about what makes a good treaty, and it's really answering the 5 W's: who, what, when, where, and why. We're not going to get into the how, because really the whole thing, a treaty is the how, right? The passing of federal legislation is the how. So that's basically what these presentations are about. I want you to think about what you know about treaties and what are the implications of the existence of treaties between the United States and the Indigenous peoples of North America. One is that originally Indigenous peoples were recognized as sovereigns, right? That's a big deal. And that there was a say that was had by Indigenous peoples for their future and how they interact with outside entities. And these outside entities were other nations: France, Spain, Britain, Russia. They all have some type of impact on the Indigenous peoples of North America. And again, I want to remind us all about the difference between a nation and a state, right? That nation is a shared history, right? We all come from the same place. We all have the same origins. And we are coming together as a people, and to help us maintain who we are as a people, we're going to develop this way of governing ourselves, this state mechanism, right? And so that state mechanism very nicely can overlay a nation and help it continue, right? If it is produced organically. And a reminder, and I've said it already, but ratified treaties in the United States are equivalent to statutes. This is really important to our discussion today, so I just want to refresh everyone's memory that once a treaty is ratified and becomes basically a statute, that the passage of other statutes can affect treaty rights. So we're going to do an overview of the laws affecting Indian treaties and their connections to tribal sovereignty and the impact that these laws have on tribal sovereignty. Before I go any further, I have to clarify some terminology. Yesterday, I started out talking about different definitions and then gave you more. You didn't notice maybe that I was sneaking them in as we continued our discussion. But what's the difference? Because people will hear federal Indian law and they're like, what is that? And is it the same thing as tribal law? They are two completely different types of law. Federal Indian law is federal law created by the federal government to affect federally recognized tribal entities. Tribal law is the internal law of a tribe. Completely different and separate. Now, as we go through today's presentation, we'll see where sometimes that tribal law and that external federal law overlap because of some federal policies and because of statutes that are passed. But do know that they are two separate things coming from two separate sovereigns, right? So you remember this from yesterday, my weird diagram, right? Well, this diagram just shows all of the links to the tribal law or the law of tribal sovereigns. So there's that hard line, and actually I could put maybe 15 arrows between the federal law and tribal law and the impact. But there's also relationships between states, local law, and of course there is that interaction with international law. I'd like to unpack it a little bit more today, because yesterday we did talk about international law and treaties and conventions and international relations and the use of the word Indigenous peoples, and we talked about different terminologies. But I wanted to give you an example of how international law really does and can affect tribal peoples. So the example I have is the UN Declaration on the Rights of Indigenous People. So this was adopted by the UN in September of 2007, and it recognizes the unique situation of Indigenous peoples around the world. I bring this to your attention as part of that dotted line between tribal peoples in the international arena, because many tribal nations from the United States worked over decades to actually get this passed. And so there was a large influence of United States tribes on this international declaration. And I have to tell you, I was fortunate enough as a law student to go to the working group session at the UN and to see all of the Indigenous people from Korea, from Africa, from India, just all over the world, any place that South America, any place you can imagine where Indigenous people exist and their interest in this document. And really, much of the language that is there was influenced by United States tribes and the sovereignty that they enjoy, which, like I said yesterday, is unique in the world. Let's talk about the types of law that affect Indian treaties. So there's federal Indian, and for federal Indian law to affect a tribe, that tribe must be federally recognized. So that's a special status that we're going to talk about a little bit later, but you can't just say, oh, I'm a tribe. You have to be recognized by the federal government, and you have to go through a process to gain recognition. This becomes very, very important as we start going through the history of treaties and the transition of treaties into statute. We have to remember that even though we talk about the federal law and tribes being extra constitutional, because the United States started treating with Indian peoples on a government-to-government relationship, that was really the embryonic state of the federal government having really control with interacting with Indian tribes. And also remember the Indian Commerce Clause as well. It's in the Constitution that Congress specifically has the power to control that. And we can spend hours talking about the intent of commerce in relationship to tribes that early and the effect of it today, but that's another session, right? We're going to also talk about the federal trust relationship and define what that is, because that's something that you hear a lot about, particularly when you talk about federal legislation being passed or agency decisions, agency regulations coming into play. When you hear questions about consultation with tribes, it's related to this thing called the federal trust relationship, and we'll talk about that more here in a minute. There are all types of legal issues at the federal level that affect tribes, right? I've listed some here: copyrights, patents, bankruptcy, federal taxes, Social Security. All of those things, even though we're talking about a separate sovereign with Indigenous nations, they come from the federal government and they affect Indian tribes and their people. Constitutionally based legal system. So again, I want to look at it and see Article 1 of the Constitution, the creation of the legislative branch. They impact tribes because the federal legislative branch can create federal statutes that affect Indian people. And this is going to come into play when we go through federal Indian policy. The legislative branch also has plenary power over Indian tribes. What does that mean? That means that Congress actually has the authority to create and terminate tribes. At any given moment, legislation can be passed to wipe out tribes. And this has happened in the past with a number of tribes, and we'll go over that when we go over the federal Indian policy timeline. That federal recognition, in order for an Indian tribe to gain their unique political status within the United States as a separate sovereign, it's the legislative branch that decides that. That's locked up within that plenary power. And also, ultimately, the legislative branch had to approve any Indian treaties. They have to now approve executive agreements that include land at some times, some agency decisions that they might have to fold into statutory language. The executive branch. So this affects tribes immensely and has over the ages, because it's in the executive branch, besides the executive having the authority to negotiate treaties, those administrative agencies that are put in place to carry out portions of the treaties, the federal regulations that create the procedures. Executive orders and proclamations can come out from the executive office and even create reservations for specific Indian tribes. And of course, the judicial branch. So the judicial branch affects Indian treaties and Indian people because they're the ones that actually interpret the language of treaties. They're the ones that actually settle disputes when they arise. So it's interpretation and application not only of treaties, but of statutes and any statutes that might affect previous treaties. I have up there the Marshall Trilogy. We'll go over that very quickly, those three cases that really set the foundation for Indian law through case law. Okay, before we get into this. So we've talked about what a treaty is. We've kind of danced around interpretation of treaties, but do know that in the United States, and this is again the influence of the federal court system, canons of construction and interpretation regarding treaties and statutes have been developed by the Supreme Court. And here are the 4 canons of construction and interpretation that apply to both treaties and to statutes. The first is ambiguous expressions must be resolved in favor of the Indian parties concerned. And that was developed all the way back in 1832 in Worcester v. Georgia, which is one of the Marshall Trilogy cases that we'll discuss later. But that's really an important canon, right? We talked yesterday about language and how important it would be if you have 2 different language constructs coming together with different historical meanings. What would the Indian nations being treated with at that moment understand that language to mean? So now we're addressing some of those issues that we unpacked yesterday, at least facially. The next one, Indian treaties must be interpreted as the Indians themselves would have understood them. That's different from the first because now we're talking about an overall interpretation when you're talking about boundaries or things. We're not talking about ambiguous expressions. We're talking about an overall interpretation. That comes from Jones v. Meehan, 1866. And you can see that these things start to evolve and you start getting more canons as time goes on. And I can tell you that there are Indian law scholars out there right now who think that there are other canons that are not so favorable to Indian tribes that are actually in play. But here the third canon is Indian treaties must be liberally construed in favor of the Indians. So up to this point, everything sounds really, really good, right? Unclear treaty provisions, which is the first one, may be interpreted from historical circumstances. So all of these canons work together so that when we are looking at treaty language and a dispute does go to the court system, these are the canons that the Supreme Court justices can and should apply. Now, they all sound great, but it's still up to the justices to actually apply the language and go through their analysis and logic. And many times they're not necessarily favorable to Indians because, as I said earlier, in even putting together this presentation and selecting things to put into historical context, there are things that are for and against tribes, for and against the federal government at any given time. And so the justices can select what they wish to select. But they do try to make a direct relationship to the understanding of the tribes in that particular area in that particular time. Okay. So the federal trust relationship. You're going to hear about this a lot. There's usually a fifth part of any trust. So these are the basic elements of a trust. The fifth part is usually the trustor. That's the person who created or the entity that created the trust. I always take it off because when I put it up there and I start talking about it, the United States really, if you look at their actions from beginning of contact with Indian tribes, are really the ones who have created this trust. It has been through congressional action, executive action, and actually through case law that have come together to define this relationship. Getting back to what just a general trust is, so there's a trustor, there's a trustee. So the trustee is the person or entity that is in charge and trusted with handling, administering the corpus, which is the body of things. And it could be money, it could be land, it could be mineral resources, anything of value. for the beneficiary. And in this case, the trustee is the federal government. The beneficiary are the federally recognized tribes, or the tribes that have been treated with. And the corpus is anything that affects tribal nations. And they have been enumerated in a number of different ways, but the basic ones are land, natural resources, and that's really associated with the land, money that has been earned either in exchange for land, in exchange for resources, and we could say health, education, and overall welfare. And we'll talk about why that is true. And all of this is supposed to happen with the trustee operating under the rules of having a fiduciary duty. That the United States government, and I try to do this without smiling, the United States government must always act in the best interest of the tribes. That's what a trust is supposed to be. So we're going to go through the history of Indian policies. And as we go through this history, I want you to think about this federal trust relationship that is being developed over this time period and is supposed to be in play when we look at these treaties. We also have other laws that actually affect Indian treaties besides federal law. Well, how can that be if really the federal government is supposed to be the buffer, the mediator, the trustee for tribes? Well, there is state law that is in play. And it's in play because the federal government has passed statutes to put it in play. There are tribal-state relations that happen because tribes and their tribal lands don't exist off by themselves. They usually exist within one or more state boundaries. And there are interactions that have to happen regarding health, welfare, police presence, fire presence. How do you address the things that happen when people live in any area? There are other legal issues that happen that affect Indian tribes and even their treaties. Landlord-tenant disputes that can happen on and off reservations. Small business, personal injury. There are all kinds of things that can happen. There are also state-recognized tribes who are trying to get that prestigious status of being federally recognized. So there are tribes that are in existence right now that have an understanding with their states. The states recognize them as some type of sovereign, and I'll say that tenuously because they recognize that these groups of people may actually have a different status, but they do not have the same protections that federally recognized tribes have. And some of these tribes had their status of federal recognition terminated, and they have not been able to get them back. And then, of course, we have tribal laws that are affecting, and just the case of tribal governments, tribal entities that have this unique political status, that are sovereign, that have their own jurisdictional issues. And it's a combination of all types of legal issues, right? How they interact with the state, how they interact with the federal government, even getting a road, even if an accident happens going towards Cochiti. Are you on state land, federal land, tribal land, right? It can become very complex. We've talked about sovereignty. We've talked about some types of laws affecting Indian people. So let's get a definition for tribal sovereignty. We know what sovereignty is. And we'll talk about the language that I used for this, which is sovereignty expressed through the lens of an individual tribal entity's history and culture. That doesn't sound very strong because I use the word lens. It looks like it's projecting something. But really, the focus that I want to put on this, at this definition, which is my definition, is expressed. When you express something, it may not be recognizable to other entities or people. Why? Because they're not used to this type of expression. This is the same thing that happens to tribal governments, and it's happened to tribal governments since the beginning and before the United States was even a nation, is that the governance of indigenous peoples that were here was not readily recognized as being a government. It was seen as being chaos because they didn't recognize the head of state. They didn't recognize how decisions were made because it was completely foreign to them. So when we think about tribal law as it currently exists, because I'm going to go through the history, but we need to talk about how it currently exists. When we have Western law, we're used to talking about, and this is what everyone in law school and every single law school learns, is that you learn that Western law is about treaties, as we discussed yesterday at the international level. Constitutions, there are constitutions all over the world, statutes, regulations, and court opinions. Most people in the United States would be able to recognize those easily, going, okay, that's law. Right now, most tribes have some sort of westernized structure. That does not mean that they do not have their own separate structure, but they had to become recognizable so that their expression of government could easily be recognized. Fortunately, most tribes now have gone back, and we'll talk about the Indian Reorganization Act, where many tribes did create constitutions, have gone back and actually put in tradition, custom, and culture, and still have unwritten law. And that's okay, even though other entities, political, governmental, over time, did not recognize those as legitimate expressions of sovereignty. This comes into play as we end up going over the federal policy timeline.
I got a question.
Sure.
It goes back to the tribal law. So, I know most tribes, or our tribe, there was a traditional way of marriage.
Mm-hmm.
You know, each family gets together and stuff, and it's understood that they're married. Husband goes to the lifestyle. So, in case if it was a traditional marriage and there's a divorce, how does that? Who the tribe's the one then has the right to determine assets, I guess.
It depends.
I mean, it's like it's unwritten. It's unwritten. It's all.
It depends. Did somebody go into state court?
I was just thinking of that, you know.
But it depends, and it depends on the individuals. Do they want it to be addressed traditionally? But I have to say, and this is that currently many individuals that have traditional marriages that way within the tribes don't necessarily want to divorce in a traditional way. So it depends. It depends on the individuals. It depends on the tribe and how they've done that expression.
See, so I would think that it wouldn't involve the court, but more the traditional people.
It depends. You're talking about it in a vacuum, and unless you actually have a concrete case, it's very hard to make that determination. I could tell you what I think about it, but it depends on that particular union, that particular dissolution of marriage, and how those individuals interact with it and who it goes to. So when it comes down to federally recognized tribes, remember we're talking about entities that are extra constitutional, and I keep saying that over and over and over and over again because it makes a difference. For example, tribal members did not have voting rights until at the federal level until 1924, even though we know locally, now this is getting back involved with state issues, within many states, tribal people would not vote until the late 1930s because of state laws preventing them from doing that. And then we had to wait until 1968 for the Indian Civil Rights Act to grant tribal peoples some type of Bill of Rights in negotiating or in dealing with their own tribes as well as amongst each other, right? Because the reason why some people struggle with that is that by this time there was a dual standard, there was a dual citizenship. If I use myself as an example, while I am a citizen of Albuquerque, a citizen of Bernalillo County, a citizen of New Mexico, a citizen of the United States, I have an additional political status as a citizen of the Pueblo of Taos. So it's additional. So while I, as an individual, have constitutional rights now as a U.S. citizen, with my status as a tribal member, I did not have those same types of rights in dealing with my tribe in tribal jurisdiction.
Does being a tribal member of Taos have international implications?
It can.
So then with...
It can. So you bring up a good point about the implications of having an extra political status if there are international implications. So there are some tribes, particularly in the East, and I know the Oneida have done this, have created their own passports and have traveled abroad, but most recently there was a lacrosse team that tried to go to an international competition and were turned away at Heathrow Airport because their passport was not recognized as being valid.
So that would apply to like the Oneida, I guess, or the Mohawk?
The Mohawk, yeah.
Because they're both in Mexico and the United States.
Correct. I mean, but there are other treaties that are in play too when you talk about tribes that exist on both sides of a fictional border. Right. So up north, what is usually not talked about down here in the south is that there's a treaty like that in the north called the J Treaty, because there are many tribes that go back and forth.
Well, I had a friend who's from Puno, and they actually go and harvest the seguro berries for traditional purposes. And so they're crossing that border.
But the Tono O'odham are actually, they're the ones that are having the largest issues right now with border walls, with being able to go back and forth. And even then, they're still having issues as individuals expressing themselves, living their lives as their cultural norm. It's still an issue. You're right, there could be an argument for that we have this unique political status. As we will see, and as I've said, the problem is that the relationship with the federal government has really morphed the sovereignty of tribal nations a lot. And we'll talk about that when we get to the Marshall Trilogy. There are so many ways that I could think of that would easily solve some of our border issues, but they're not so easy, right? They're not so easy because of the political climate, the different jurisdictions that we have to get involved in approval from. It's just not as easy as you would think. Unique political status, sovereignty, and jurisdiction. So that unique political status, here's another way of thinking about it and answering that question, is that unique political status is in relationship with the federal government, not necessarily other nations. Even though tribes have been trying to express their sovereignty through things like passports. Within the state of Oklahoma, I know some of the tribes actually have their own license plates and have their own state licensing system. So there are different ways of expressing, but remember that unique political status exists with the greater sovereign in which these tribes exist within the boundaries of a different jurisdiction. Does that make sense? Yeah. Hopefully we'll get a little bit.
I wondered, you just mentioned, so that's only the sovereignty is in relation with the United States code.
Allows. So in Japan, actually, the beginning of this year, the end of last year, an indigenous people was just recognized in Japan. They had been there, they had existed, but they only have any type of special status because of their relationship with the Japanese government. The same is true here in the United States. That the tribes right now are existing with this unique political status because the United States federal government recognizes them. Now, I'm not saying that they wouldn't exist without this, but what I'm saying there is that a legal status by a greater sovereign has been recognized. And that is what you're trying to get at, is recognition of a sovereign by another sovereign.
So would it be able for the sovereign tribe to do business with Japan? Or does it have to go through?
It still has to go through the United States. So the United States says. Because you're asking the big questions, so I'm like, well, sure, if they can get away with it.
So I have an example of that. So Cuba did some kind of commerce arrangement with NAPI, and so there's some trade or something going on there.
There is, but it could be stopped at any moment by the federal government. Any moment. The other example, I think that might help clarify it for you, is that the state of New Mexico is a sovereign, but it's a sovereign within the United States. So they still have to abide by some federal rules, but there are other federal rules like the use of the legalization of marijuana that is not acceptable at the federal level. So there's a struggle there. And so that concept of federalism that I said is really between the states and the federal government also constantly exists with the tribes. Tribes are constantly trying to figure out how to expand their expression of sovereignty.
How do gaming compacts follow that? That's between the state and tribes, is that right?
Well, but it has to be approved by the federal government. So you see that all roads lead to DC. That's the easiest way. Okay, so we're so used to here, particularly in the Southwest and across the lower 48 contiguous states, of talking about tribes and Indian law with really only talking about the lower 48. But there are other indigenous people that are parts of the United States that have treaties as well, that were affected by international treaties, and those are the Alaska Natives. Now, this treaty of cession with Russia happened in 1867. It accepted uncivilized Native tribes from the rights of citizenship. So you see how an international treaty can recognize or accept or exclude indigenous peoples. They were not at the table when that treaty came into being. It was between Russia and the United States. The clause about these uncivilized tribes being subjected to the laws of the United States. So even during this session, within that particular treaty, they said, okay, so all of these uncivilized, I'm using air quotes every time I say uncivilized, people, it said, okay, we're going to now make the people living here subject to the laws of the United States, whether they like it or not. The United States really couldn't do anything about it. That's not what their focus was. But let's contrast that to the Treaty of Guadalupe Hidalgo, right? Who did not specifically call out uncivilized tribes, just everyone was a citizen. And you can see the effect, the different effect of a treaty that specifically addresses indigenous people versus one that just said, okay, we're all citizens. We could talk about that too in a completely different session. But so in the Organic Act of 1884, for those of you that don't know, an Organic Act is when a area of land is going to become a state. They're like, okay, so this is now a part of the United States. When that happened, when it truly became a part of the United States, they extinguished Aboriginal title, but didn't really acknowledge whether Aboriginal title, in other words, the use of lands in Alaska by its indigenous population, ever really existed. It's weird, and this does not get settled until the 1970s, and we'll get to that when we get to the timeline. But we've got to talk about it because the Alaska Natives have a little bit different history that I'm not going to address in the timeline, to make sure that we understand that it's separate and different. So the Alaska Native Claims Settlement Act, it extinguished any claims of Aboriginal title. Notice when this happened, and that is a correct date. That did not happen until 1971. So that's why when you talk about Alaska Natives, they're not called tribes. they're called corporations. They can operate more like corporations and don't have as much of a tie or the same tie to the federal governments as many of the tribes do in the lower 48. Okay, so you have regional villages, how the individual members can get mineral lease money. That still can happen in the lower 48, but it just developed differently in Alaska. I also have to bring up the Native Hawaiians, particularly right now. The kingdom was overthrown in 1893, and I can talk about the very ugly and bloody history of that, but I will decline for today. Congress has included Hawaiians in Indian legislation since 1974. So while the Native Hawaiians, until very recently, were not considered federally recognized tribes, and they still really aren't, they were still included in legislation that affects or for the benefit of Indigenous tribes. It wasn't until 1993 that there was an apology and a reconciliation by the United States government to the Hawaiians for that very bloody history. So during that time period, Hawaiian natives were trying to gain that same unique political status, that same relationship with the federal government that tribes in the lower 48 contiguous states have. So they took it to court. There was a case in 2000 in Rice v. Cayetano that said, you know what? Hawaiians are a race and do not have the same unique political status. So for a very long time, that was the end of the discussion as Native Hawaiians being a part of Indian federal regulations. They were just mentioned. However, in 2016, there was a final rule issued by the Department of Interior outlining a procedure to federally recognize a Native Hawaiian government. And I'm happy to say that Kevin Washburn, who was once a dean at my law school, actually was Assistant Secretary of the Interior that helped get that rule finalized. So this is still in process and in play for Native Hawaiians, so they may too gain some type of federal recognition. But remember, we're not doing treaties anymore, so they're not going to get a treaty that will affect them the same way.